Yes, sir.
So whenever you guys are ready, I guess, let's see, wait. So this is me. We're gonna be talking right now about protecting your intellectual property. We're gonna be talking a little bit about what it is, what are the types of intellectual property. This material is available on your, it may not be exactly the same colors, but the content is basically the same. And you should be able to take some notes in there. So we are here on Wednesday evening. Welcome everybody at the Central Phoenix Library. And for those of you watching on Facebook, thank you. Thank you for taking your time to watch me. Hopefully this is going to be a fun class. And I guess all of you are monolinguals, right? Nobody speaks any other language or needs to have any translation. What other language? What's your superpower?
Hopi and Spanish.
Hopi and Spanish, okay. But it doesn't look like I need to translate to you into Spanish. Okay. Yeah. I couldn't translate into Hopi either.
He can see right here, I can translate.
You can translate for him, yeah, if you need any translation into Spanish. So my name is Marcos, you can see it here. I'm an attorney, I'm a local attorney. I live in Chandler, for those of you that are in the East Valley. And I focus on business, intellectual property, so we're gonna be talking a little bit about that quickly. Just, legalese. This is not, like some other friends say, I'm an attorney, but I'm not your attorney until you hire me. Okay? So whatever I tell you, take it with a grain of salt. Educate yourself. I always tell people an educated client is the best client that you can have, as an attorney at least. And I guess it applies almost on anything. So I'm here in Arizona. I provide a lot of work via online. Doesn't necessarily mean transactionally online, but I'm in Chandler. We don't have to be sitting face to face for a lot of this work. I do have some clients that are all over the world, and one of my best clients, I've never seen her in person, and I've only talked to her once over the phone. So that's, we get along great. Intellectual property, I guess that could be one of the ideal relationships. Business, intellectual property, legal services. I do a lot of work with Spanish-speaking people, mostly entrepreneurs, business owners. Try to be, as much of an advisor for you and your business and your personal matters as well as possible. Some of the things that you may need. We're going to be focusing today on the trademarks, a little bit on patent and copyright, and we're not going to be covering much of anything else, but I can help you on some of that stuff. I mentioned business, brand, immigration attorney. I mentioned brand because most people, unless they really know the lingo, you tell them intellectual property is like, trademarks. What is that? Copyrights, like, yeah, I've heard about it. So if you mention brand, it's like, oh, okay. So I try to help also not only on protecting, but figuring out if that's probably the best one, at least from the legal perspective. Your commercial or artistic, that's a different animal, but I'll try to help you as much as possible. I'm an engineer, besides being an attorney. Industrial engineering as well. I work on a bunch of different things throughout my life. That's my email, that's my Twitter handle, and you can find me also on LinkedIn or just text me. And I always like to do this quick exercise. Grab your phones Okay, and if you have Twitter, Instagram, or Facebook, or if not, just text your name. You can go here and send me a tweet. Just say hi. Now, if you do this, I'd like you to do this if possible, because then that will help me, get up in the rankings and things like that. Search engine, stuff like that. And then go to my webpage and just click on blogs. And there's a bunch of different articles I produce, about one a week or every other week, about different topics, especially stuff that is out there in the news. I had one, although we're not going to be talking about non-disclosures agreements, but I had one or two articles about non-disclosure agreements related to Donald Trump and all his girlfriends. So, it looks like if you go out with him, you end up with $100,000 or more, but you have to sign some papers. Intellectual property. Let's get down to the meat. And what are we talking about intellectual property here? Oops, what did I do? Okay, got it. Why are we talking about intellectual property? And what does that have to do with you? Well, for most of you, whatever you're doing as a business, and I assume all of you are here preparing for the pitch or entering into the pitch competition. Okay, so for those of you outside the room, Hive, which is the incubator here for the city of Phoenix in the Phoenix Library, is going to have a pitch competition in September. Look it up, Google Hive Phoenix Central Library, and come over and listen to all these wonderful people. So all of you have some business or a business project. Well, believe it or not, but for the most part, whatever you're doing is irrelevant as a product or a service, except for one thing, and that's yourself, because that's the thing that you're doing. And you're putting a special twist to that. You're doing things a little bit different. Hopefully your product or your service is better than whoever else is offering it. But even if it is not, in many cases people will choose you over somebody else because of things that are not easy to put a finger on. It's like maybe the flavor, but maybe tastes the same. You offer a little bit of a better service. At the end of the day, it becomes what is called your brand. Okay, whatever you do that creates a difference in the mind of the people. And all that stuff, comes out from your mind. Sometimes you cannot put a finger on it. It's like, oh my God, I don't know, but I like working with this person, or they do good service. You can pick anybody, but I prefer to call this guy. That is basically something that is created on your mind. And somehow you should be able to protect it, okay? So all that is called intellectual property. Now, not all things that come out of your mind are worth necessarily protecting or can be put into some shape that can be protected. I said it's intangible. Sometimes you cannot grab it, but you can embody it. You can put it somewhere that starts, taking a shape or something. And we'll go into those details. Like any other property, and this is one of those things, it gets a little bit nerdy with the attorneys. It's property is just a bundle of rights. It's like, oh, what do you mean? Okay, if it is something that you can buy, you can sell, you can transfer, you can give away, you can register, somebody can steal from you, it is a property. And intellectual property meets all those criteria. One thing that is important, and it kind of confuses sometimes some people, is intellectual property is in general ruled by global principles because of international treaties, okay? That makes it a little bit easier to understand across different countries and across different jurisdictions and languages and things like that. But at the end of the day, it's local protection and local registration. So if you have a great idea and you register in the United States, but you didn't do anything in China, guess what? You're not protected in China. In some cases, It has evolved from common law, and I'm not going to get too nitty gritty on common law, but it's just basically practice, things that, why is this the law? Well, we've always done it that way. It's like, what do you mean I shouldn't steal from other people? Like, yeah, we said for thousands of years, don't steal, okay? So that's really common law. You don't need anybody to tell you that. Except for the patents, which are, at least for the United States, it is spelled out in the Constitution. And Thomas Jefferson was one of the first patent examiners in the country. And registration, this is important, registration of this property, just like any other property. You have a car, you have a house, you have what have you. If you don't have it registered, people don't know that you are the owner. And if there's a dispute, you're not going to know who's the right owner, but usually the one that produces a title is going to end up winning, or at least has a better shot at winning. Okay? So you have this property, you have this idea, you have these things, you think you can put it on something. Why do you protect it? It's going to cost you money, let's be honest. It's going to take some time. You want to protect from the competition. You don't want, if you're the first one that came out with the name Coca-Cola and you didn't do anything to protect it, you wouldn't want somebody, can you imagine somebody else using Coca-Cola or somebody just going around using Coca-Cola like that? You wouldn't like that to happen. A lot of big companies are very jealous about that, and they spend a lot of time and money. They have armies of attorneys suing and sending cease and desist letters. Disney, for example, is one of those. Movie makers, film studios, they are on top of that all the time. It has some value, you can differentiate yourself. Sometimes that is everything that can differentiate a pair of shoes from Nike as a pair of shoes from X Factory. Yeah. You can turn that into some business opportunity, revenue. May not happen necessarily with brands or trademarks, but on patents, there's people that could make a business model just from creating inventions and licensing to other people. And there's also personal satisfaction, especially in the big companies. The big companies, you work for them, and whatever you create belongs to the company. So as an individual, you're not going to be benefiting a lot from your inventions or your creations. But for patents, I'm talking patents, although I'm not going to be spending a lot of time on patents. But they'll give you a plaque, and they'll give you a $2,000 bonus for every patent that you can get through. And that's it, okay? You can say, hey, I have a patent, or I have 5 patents, whatever. So I'm going to be spending a little bit of time in here, and then we're going to talk specifically at each one of those points. The way I created this one is kind of self-explanatory. You're going to be expected to have a few patents in your business. You may have 0 patents depending on the kind of business you're into. Most likely you will need a few trademarks for protecting your brand or your products or your product lines. You may want to have a good number of copyrights depending on your business. If you are a photographer, or if you create content, like you make movies, or you make art, or you make clips, or you make stuff like that, that is original, you're going to have a lot of copyrights that you're going to want to have in there. If you make, I don't know, consumer products, fashion, you're probably going to have a lot of trademarks in there. If you are more industrial, you're probably going to have a few patents. You may also have quite a number of trade secrets. Trade secrets is just like the name says. It's secret. It is related to your business. And by being secret, it means that you don't want anybody else to know. And think of like Kentucky Fried Chicken and the Coca-Cola formula, where nobody knows what it is except the people that are going to be pouring the stuff to make this happen. Okay? So this one over here, the one at the top, they're going to take you more for processing. A patent is probably going to take you 3, 5 years, and it can cost you $10,000, 15 or more, in order to get it through the whole process. A trademark is going to be about 6 months to a year, maybe 2 years, depending on what country you go to. 6 months is in the United States, and total cost maybe probably around $1,000 per trademark, maybe 2,000-3,000 in other countries, depending on where you want to go. Copyrights are going to be also cheaper and faster. You know, you're talking about a few $100 and maybe 3 to 6 months to get it through the process. And trade secrets, as long as you keep it secret, you know, you're good. The other one that I put in here that it doesn't quite fit into any of these, although it could be on a number of different categories, is your personal likeness and your privacy. You know, your own person, your image. When you come in here and you sign a disclaimer and a waiver about photography and things like that, well, that's because you are the owner of your persona and your image. And if somebody else wants to use it, they need to have your authorization. And depending on who you are, let's say you are Kim Kardashian, so just by virtue of who you are, there is also a brand, that's a trademark. And if somebody wants to use it in connection with certain things, there's some value there. Just all her photos and everything else, they could be copyrighted, stuff like that. So, we talk about registration. Registration is a process that you do at a specific agency of the government where you want to have the protection. So the United States, in the United States is the USPTO, United States Patent and Trademark Office, or it's also the Library of Congress for copyright. Why do you want to have it? It's like the title of your house. And if you sue them because they violated your trademark, then, or your rights, then it becomes, you know, you get a minimum of damages, about $50,000 per damage, you know, without having to prove that they really damaged you. I don't know if anybody heard recently, it's like in the last month or two, about, and I don't remember all the details, but there was one of those revenge porn situations where a guy took pictures. I think it was a politician. He took pictures of his girlfriend or something, and then he leaked them or sent them to somebody else. And what she did is she went and copyrighted the pictures, and because they were put out on the internet, so the cat was out of the bag. What he did is she copyrighted those ones, and then she sued him $50,000 for each instance of him releasing those pictures to other people. So she got like $2.5 million worth of damages, because it is, you know, if he did it 50 times, and she didn't have to prove that she suffered $2.5 million. It's not like you broke an arm and it cost you $100,000 to get it fixed, okay? So that's what she got. Also, Border and Customs injunction. If you don't have a registration, they will not act on you. You've seen on TV some of these raids that they do on companies that are bringing fake shoes or fake operating system or movies, pirates. And you got the border. You basically have the government working for you to stop those shipments and destroy them before they can get into the market. On social media, you don't have a registration number, especially for copyrights or trademarks. And it's not only social media, but it's also some of the retail places like Amazon or eBay. If you go and call them and say, hey, this guy is selling shoes that are my brand and I never authorized him to do that, those are fake, then they will take them down, but you have to show the registration. Okay? So, just a few examples. The trademark, the purpose of the trademark is to identify the source of the goods and the services. And it could be anything. In some places, it could be a smell. Although there's a little bit of balance or confusion between, okay, how do you define a smell? A sound, yeah, we can get it. Taste and smell, that's a little bit different. So they are still debating that, but a court in Europe, declared that the smells can be trademarked. Basically, the scent of Chanel No. 5. Okay, I don't know what it smells like, but I guess some people do. So when you see these R's in some of these logos, what it means is that somebody went through the process of registering and got the registration back. Okay, got the registration approved. The goal that you get with all these things protecting trademark is that you don't try to use something like this for another product, trying to fool people into believing that it comes from these guys. That's basically avoiding confusion. That is the goal that you have in here. One big question and one big mistake that people have is they go and register their name, the name of their company, into the with the state, Corporation Commission in our case, and they think they are set. Well, that's not enough. Okay, they just care about the specific portion of your business, which is the legal registration, so you can have certain liability protection. It doesn't do anything to protect your the name of your business or the name of your product. If it does, the only thing it does is protect it for a limited jurisdiction, which is the state where you register, and only from the time you were. And if somebody else was using it at a national level before you, then you probably don't have any rights over that. And again, just because you have a name for your business, that doesn't necessarily mean that that would be the name of your product or service or the protection that you, or the names that you want to protect, okay? Question, lady?
So yes, for trademarks, differences between the name of your business, the acronym for your business, and or the icon for your business.
Exactly.
Are they all under one, or do they each have to be separate?
Each one is separate, and also, for example, Chanel. Okay, dresses, shoes, bags, perfumes. Do they make anything else? Oh, cosmetic. Well, perfume, cosmetics, jewelry. Beautiful. Shoes, we already said. Each one of them, except with the shoes and the clothing, they are on the same category. Hats, shoes, pretty much anything that you put on your body. All that stuff, it's one category. So you have to file under that category for that product. For Chanel, that would be one. The 2Cs, okay, that would be another one. Something else, that would be another one. Same thing with jewelry. Same thing with perfume, cosmetics. Same thing for whatever else.
And if you register in the state of Arizona, but your end goal within 10 years is to be global, and or your website is already available to the global market, if you only applied in Arizona for a trademark, are you no longer protected if somebody in another state or global?
You're not protected anywhere else. And your protection in Arizona would be fairly limited, I would say.
The protection, what was the last line? I didn't hear it.
Would be very limited in Arizona.
Okay. So I would say I got a trademark, but the thing is, I wasn't sure. I got it from the Secretary of State.
Yeah.
I got the certificate and all the proof. I'm working on logo now. But from going from one state, which is covered, to going to national and not just global, does that mean I gotta go to each state SOS to get this thing down?
You come to me.
Just go to you?
Yeah.
There's like one federal,
There's one federal
but there's not
registration.
one global, right?
There's not one global. No. No.
So
Sorry.
you're saying the name is unprotected, but if the name is like, okay, my business is a service, but the name, so I do my name and then I do the service is different?
No, it only protects for the service, for certain product or service. You have to pick the level, where it gets the protection. So like for example, you're gonna make shoes, you put it for shoes and you only get protected for shoes. I used to have it in here, but there's a good example, Delta, 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 Delta. Okay, Delta Airlines, Delta Faucets, Delta Dental, Delta Power Supplies. Okay, it's completely different products and services. And each one can get the protection because they are completely different. Okay,
But
and
know
each
that-
one is a
but know that
different.
There's 5 different deltas, as you just mentioned. Okay, 5 different deltas, 5 different entities. Well,
Could be.
living business, having businesses, okay? And not just business confusion of worries. Because when I say delta, like you said, there's 5 different deltas you just mentioned.
Yeah.
And it's like confusing. The distinction is definite. The distinction between.
So I'll show you an example in a second. I'm
Sorry,
just
I didn't
gonna.
interrupt.
No. I have something to show you in a minute. So I
Okay.
just want to go quickly here that not all trademarks are created equal. If it is something that is very generic, no, you're not gonna get it. If it is something, the best ones are the ones that are fanciful or what is called arbitrary, like Apple for computers, Sun for computers. Well, actually, you couldn't trademark Sun anyway because you don't own the sun. But sunscreens, for example, you know, if it is for sunscreen or for sunscreens, no, you cannot have it. But if it is for something else, you could. Lotus is not for plants, it's for software. Microsoft, the same thing. Descriptive, and that's a lot of problems with doctors and dentists, because everybody wants to talk about teeth, health, medical. It's like, that's very generic and very descriptive, so you're gonna have to have something else. This is a good example, and I was showing somebody, probably here you got Dr. Pepper, it is protected, probably the, you know, the fonts or the shape or the way they are presented, and also the color of the can, the whole thing. So any of these guys may be violating the rights of Dr. Pepper, for example.
That actually brings up, so our colors and fonts, a whole other trademark then?
That could be another complete trademark. You could, and one of the things that you gotta be careful is when, and that's the stuff that you don't have to worry about, that's what I worry about, is you cannot just say, hey, I got these letters, words on this font. Because if you're using a specific type of font from somebody, you need to have the rights of the owner of that font. Yes, sir?
Yeah, I was gonna say, can you like talk a little bit about first rights? Like in a case like that, what if I just, that's my handwriting and then somebody sends me a cease and desist, and it's like, well, I own this copyright to this, but I've been drawing like this forever.
Well, it depends on how much confusion is going to create in the market, and who was the first owner, you know, who started using it first, and who was the first one that was in the market. Okay, copyrights, very quick. It is the whole thing, the whole book, the whole movie, the whole music. Trademark is very short. It is the name of the, could be the name of the author, it could be the series, it could be just the name of the shoe or the company that makes the shoe. Here it is the whole thing. Trade secrets, as we said, keep it secret. It is anything that you could consider to be so personal to your business that if it goes out could cause you a problem. And remember, trademarks, patents, copyrights, all that stuff is public. I mean, what's the purpose of having a brand if you are not going to show it? Trade secrets is different. Basically, patent is a machine, can be a tool, could be a formula for example, a medicine, a prescription, a drug. Has to be unique, has to be novel, new, it has to be non-obvious. So those are the 3 rules, and you have to be the first one to be filing for that globally, actually. This has more impact, although you only get protection in the United States. Somebody already has that somewhere else, you cannot have it. Okay, you usually get it for 20 years, and it's only for the place where you file. So you have to be very careful with those things. And finally, I have here an example. This is one of the companies, one of my clients. It's a Mexican group. They've been playing since the 70s. One of the players, one of the singers decided to start his own group using the name. They even started filing. We went and opposed, were able to get them to stop doing that, and then we took them down on social media. Musicians, they have songs and videos all over the place, so we took them down. This is a picture of the group, and this is the report that we did. And a few other clients that I've been working with, all kinds of things from restaurants to music groups and clothing. And I think that's it, because I was out of time anyway. No, that's okay. Any other questions that you may have before we are, I don't know what time it is.
What would you
Yeah.
consider then, out of the different things that you presented, what's the best way to protect the name of your business?
The only way, I think, is to register it, definitely. There's no way around it. I mean, if it is something like, if you said, oh, I have this formula or this, salsa, whatever, or sauce, like, well, don't tell anybody, keep it secret. That's the way to protect that specific thing. But for the name itself, it's gonna be out there.
I want it to be.
You want it to be, so you better have the seal that says, hey, don't mess with it, it's mine. And that's what registration does for you. Tracy?
So if we say like we do have our business registered and trademarked
In the state.
in the United States,
Oh, in the United States,
In the United
nationwide.
States.
Okay.
do we have the right to go foreign trademark
Yes, you can.
once we register throughout the United States?
However, that's why you have attorneys. Just because you are able to get the trademark in the United States doesn't mean you can get it in another country.
Based on what the language barrier may be.
That's one. You're very smart for me. There's other ones. There could be the same trademark that somebody thought using over there. It's completely independent. They do that a lot in China. They look at what's selling here, what is the brands, and then before it becomes global, they go and register over there. And there is.
2 quick questions.
Okay.
One,
Hey,
if
she's the
you're-
one that's gonna kick me out.
Okay.
not me.
If
Go ahead.
if your name has an LLC because of limited liability corporation, whatever, is it okay to trademark it without the LLC? or is
Yes.
that a problem?
Yeah, I would trademark it as simple as possible.
Okay.
The root, I call it the root. Like for example, if you're gonna have blah 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 cosmetics, blah 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 shoes, blah 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 LLC, just do the blah blah blah. Okay. The rest, it would be a waste of time and money because the other elements are generic. You couldn't protect them anyway.
And then the second question is, if you were to generate your business model or anything off of like Word document, and so you're using Times New Roman, are there problems there considering like?
No, not in general. The only problem is when you start making the specific requirements that when you do a registration, it is kind of universal. So you say, Teresa McNulty, okay, that's your trademark. It could be like if you're an artist or you're a designer. If I make it with any font, it's still protected.
So Microsoft isn't going to come after you because you're using their
No.
font.
I apologize, we have other person watching.
Yeah, I'm sorry. But I'm here.
Yeah, we can take some questions if you'd like to ask more questions at the end.
Yeah, I'll be here for a few minutes. Come on, vente. Yeah, otherwise I'm not gonna stop. Okay, so I'm gonna cut off the transmission. Thank you for all of you guys watching, and tell your friends. Okay, bye.